Welcome to LondonLawTutor.com. In this short lecture, we'll be focusing on land law. Land law is the area of law that governs the different forms of ownerships and rights in relation to land. We're concerned with real property here as distinct from personal or movable possessions. The modern law sources of land law derive from a mixture of common law, equity law, and statute law. The main statutes that you need to be aware of are the Law of Property Act 1925, the Law of Property Miscellaneous Provisions Act 1989 and 1994, and more recently the Land Registration Act 2002. Before we look at some of the topical issues, it is important that from the outset you are familiar with the definitions of certain key property concepts. Firstly, an estate in land. What does this mean? Well, essentially, an estate in land refers to the rights and interests a person has over a plot of land. Traditionally, it was viewed that all land belonged to the Crown, and therefore when you buy a property, you were actually buying rights and interest in the land. Pursuant to Section 1, subsection 1 of the Law of Property Act, there are now two types of estates in land capable of subsisting at law. The first is an estate in fee simple absolute possession, in other words, a freehold estate. And the second is a term of years absolute, in other words, a leasehold estate. Now, taking the first estate in land, a freehold owner enjoys the most extensive absolute rights in respect of the land. This can be contrasted with a leasehold owner who merely enjoys exclusive possession of the land for a fixed period of time. Now let us consider what an interest in land is. An interest in land can be either legal or equitable. The word interest in relation to land refers to rights a person enjoys over someone else's land. The list of legal interests can be found under Section 1, subsection 2 of the Law of Property Act, and most notably this includes an easement. An easement is a right-of-way over someone else's land. The categories of equitable interests include a beneficial interest arising under a trust. A trust exists when a legal estate is held by a trustee for the benefit of a beneficiary who holds equitable title in the property. The category of equitable interest also includes a restrictive covenant. A covenant can be either positive or restrictive in nature. A negative or a restrictive covenant is a promise by one person not to do something on someone else's land. A positive covenant is the opposite, i.e. a promise by one person to do something on someone else's land. Now that we've looked at estate in land and interest in land, we can move on to consider some of the other topics in land law that you might come across. These include mortgages or a security interest in land, looking at the nature of easements and covenants, how they are created, and their binding effect on successors in title, both in law and in equity, adverse possession, and leases and licenses. You will also be looking at the registration of title, and I deliberately kept this last because it's a very important aspect of land law, and I want to look at this before we end this lecture. Land registration describes a system by which ownership and interest in land can be recorded. The purpose of registration is to simplify conveyancing and for the land registry to reflect the totality of estates, interest, and charges affecting the land. In effect, the registry acts as a mirror, reflecting the full range of proprietary interests and benefits in the land. The extent to which the system of registration achieves this is questionable, since there are many categories of interests which do not need to be registered. Following the Land Registration Act 2002, dispositions of unregistered land will now trigger compulsory first registration. Dispositions of registered estates also have to be registered under Section 27 of the Land Registration Act. The effect of registration is found in Section 29, which in simple terms states that a registered proprietor of land will take priority over interests which existed immediately before the disposition, i.e., for example, a transfer, and whose priority was not protected. The section further goes on to tell us how a priority can be protected. A priority of an interest can be protected by either being the subject of a notice in the register pursuant to Section 32, or if it is an overriding interest under Schedule 3. Land law is a very complicated area of law, and you will have to refer to the primary and secondary sources of law in order to get a good understanding of its elements. Nevertheless, I hope this brief lecture was helpful. Thank you for listening.